Episode 6. Are Puerto Ricanos second-class citizens? Many scholars and lawmakers in the United States recognize that having equal membership to a community is more an ideal than a reality. Instead of striving for a greater level of equality, enhancing the status of American citizenship, and increasing the number of citizens, the U.S. has done the opposite. This is apparent when we look at the second-class citizenship that was given to Puerto Ricanos in the 20th century. In 1917, the Jones Act unilaterally naturalized Puerto Ricans by congressional statute without their consent. Later, in 1940, the Nationality Act established that all persons born in Puerto Rico after January 12, 1941, would be considered birthright citizens. However, the U.S. courts had not yet recognized the inhabitants of any of the unincorporated territories, including Puerto Rico, as having full constitutional rights. As a result, unlike people born in the United States under constitutional birthright citizenship, people born in Puerto Rico acquire statutory citizenship, which relies exclusively on Congress's will, making it possible to be withdrawn at any moment, although it is unlikely. The statutory citizenship of Puerto Ricanos has been used to justify restricted access to citizens' rights. For instance, in 1922, Congress determined that most of the civil rights established by the Constitution, such as the Bill of Rights, do not automatically apply to U.S. citizens in Puerto Rico or other unincorporated territories. Moreover, during the drafting of the Constitution of the Commonwealth of Puerto Rico in 1950, U.S. President Harry S. Truman asked Governor Luis Muñoz Marin to remove Section 20 of the original Puerto Rican Constitution. This section recognized rights such as social protection in case of unemployment, sickness, old age, or disability, the right to work, an adequate standard of living, and the rights of mothers and children to special care and assistance. The duality of the Puerto Rican Commonwealth continues to the 21st century. In 2016, while Puerto Rico faced a public debt that could not be paid, the Supreme Court determined that Chapter 9 of the Federal Bankruptcy Code excludes Puerto Rico from its provisions. For this reason, Puerto Rican municipalities are not allowed to file for bankruptcy, as mainland municipal governments can. In later years, the Puerto Rican government sought to remove this limitation without success, leaving Puerto Rico to face another hurdle, PROMESA, a fiscal control board overseeing and, in many cases, vetoing Puerto Rican local government. Yet, many Puerto Ricanos from the island and the diaspora have courageously challenged the U.S. limitations on their rights, opportunities, and powers. From the Aspira Consent Decree of 1974, which guaranteed equal access to education for Puerto Rican children in New York, to the Puerto Rican Status Act of 2023, a proposed bill that could enable the residents of Puerto Rico to choose fully self-governing political status. Puerto Ricanos have been at the forefront, working as allies with other communities to ensure the well-being and respect of the full citizenship rights of all Americans.